You know that feeling when you sign something without really reading all the fine print? We've all been there. But what happens when another business does the same thing and their fine print totally clashes with yours? Well, that's what we're talking about today. We're diving into something called the Battle of the Forms, a classic legal showdown where the tiny text becomes the main event. This is where things get really interesting. All right, let's imagine this for a second. Picture yourself running a business. You need a critical part for your product. So you send off a purchase order with your company's standard terms and conditions. Simple enough. The seller gets back to you, ready to go, but they send an invoice with their own set of terms. So you've got a deal, right? But whose rules are you playing by? This isn't just some textbook problem, folks. This happens every single day, and it's exactly what our story is about. And believe it or not, this exact situation has a name. It's called the Battle of the Forms. It's basically when two companies move forward like they have a solid agreement, but behind the scenes, their documents are in a full-blown war with each other. So you gotta wonder, when the whole thing blows up, how on earth does a court figure out who comes out on top? So to really get how this all works, we're gonna look at a real-life case. Think of it like a legal boxing match. In this corner, we've got the seller, Butler Machine Tool Co., and in the other corner, the buyer, XLO Corporation. They thought they had a simple deal for a machine. But what they didn't realize was that a huge disagreement over the price was hiding in their paperwork, and it was about to spark a case that would change the rules of the game. Okay, so here's how the paper trail went down. On May 23rd, Butler kicks things off. They send a quote for a machine, and of course, it's got their terms and conditions attached. Just a few days later, Excello responds. They place the order. But, and this is the key detail, they use their own form with their own terms. And their form had this little tear-off slip at the bottom for Butler to sign and send back. So on June 5th, that's exactly what Butler does. They sign it, they return it. Seems pretty simple, doesn't it? Well, that one little piece of paper would become the biggest piece of evidence in this whole dispute. So what was the big deal? What was the ticking time bomb buried in all this paperwork? Well, Butler's terms had something called a price variation clause. Fancy name, but it basically meant they could raise the price later if their costs went up. But XLO's terms, nope, nothing like that. For them, the price was fixed, period. So you can probably guess what happened next. When Butler tried to add almost 3,000 pounds to the bill, XLO said, no way. And that's when the lawyers got involved. All right, so with a fight on their hands, the court had to figure this out. And their first move was to pull out a classic tool from the legal toolbox, something called the last shot rule. So what is this last shot rule anyway? Honestly, the best way to think about it is like a game of ping pong. Party A sends over an offer, that's the serve. It has their terms. Now, if Party B replies with different terms, that's not just hitting the ball back. It's a whole new serve. It's a counteroffer, and it completely wipes out the original offer. If Party A then just carries on with the deal, the law says they've accepted that counteroffer. So the contract is based on whatever was in that final document, the last shot that was fired. Okay, so let's apply that rule here. Who fired the last shot? You'd probably say Butler, right? I mean, they sent back that tear-off slip on June 5th. That was the very last piece of paper to be exchanged. So based on the old school rules, Butler should have won this thing hands down. Or should they have? This is where the case gets really good. Yeah, it really looked like an open and shut case. It seemed like Butler's last shot hit the mark. But the judges at the Court of Appeal, especially this one legendary judge named Lord Denning, thought, hang on a minute. They felt that just applying this rigid rule didn't really make sense for how modern businesses actually work. So they decided to throw out the old playbook and look at this whole thing differently. And Lord Denning's perspective here was a total game changer. He basically said that this old robotic way of looking at offer, counteroffer, acceptance, it was just out of date. He put it perfectly. He said, the better way is to look at all the documents passing between the parties and glean from them whether they have reached agreement. What he was really saying is, let's stop being so rigid and let's try to figure out what these two companies actually agreed to. I mean, this was a huge deal. It was a massive shift in how the law looked at these things. Instead of just focusing on who sent the last piece of paper, the court said, we're going to look at the whole story. They wanted to find the real substance of the deal, not just get tangled up in the order of the paperwork. So, with this brand new way of looking at things, the court reached a pretty surprising decision, and it has some really important lessons for any of us dealing with contracts today. And the winner was XLO, the buyer. The court's final ruling was that Butler had no right to charge that extra cash. So, why? What was the logic?
Well, the judges looked at that May 27th order from ex-Salilo and said that was a clear counteroffer. And the killer move? When Butler signed and returned the tear-off slip from XLO's form, that was it. That was the moment of acceptance. It was a physical act that basically said, yep, we're agreeing to your terms. So what looked like Butler's last shot, well, it wasn't a shot at all. It was actually a white flag of surrender.
So, what are the big takeaways from all this? First and foremost, the last shot rule, it's not guaranteed to work. A court might just look at everything, the whole back and forth, to figure out what you really agreed on. Second, what you do can matter more than what your pre-printed form says. Signing and sending back that specific slip was a huge action on Butler's part. And finally, and maybe most importantly, clarity is everything. Be crystal clear about whose terms you're operating on, because at the end of the day, a court is just trying to find the true agreement between you.
You know, this case is from a while back, but it brings up a really important question for today. Think about your own business, your own deals. Are you absolutely sure you're making a clear agreement? Or could you be accidentally starting a battle of the forms without even realizing it?